It turns out that 2016 is the year of referendums. Across in Italy, over in the UK, in Bermuda, where I chair the Constituency Boundaries Commission, in Antigua, Barbuda, where I am consultant for the referendum coming up, in the Bahamas, and here we are in Grenada. The Grenadian offer is by far the most ambitious of all the referendums taking place across the world this year. And let the record show we started it. We were not following anybody else. As Ms. Sylvester told you, we started in 2014 talking about referendum. But it is good to have company, and good company including the UK. We have 8 bills on the offer. We started with 6. And then we split one into 3 based on representations made at exercises like this. That is important to bear in mind because we come here tonight in Victoria partnering with a civil society organization. And it is because of representations made by civil society organizations that although we had already read one of the bills, first time in the House, that bill was withdrawn and out of it came 3. That's important to bear in mind because it shows the extent to which we are hearing the people's voices across the country. Good to have Mrs. Thomas here with us. I think you're motoring all the way from Guelph, more or less. Good to have you here. And we have people like Agar Alexander, very distinguished former permanent secretary and ombudsperson. Everybody, of course, is important. But we can't be from recognizing leaders in the community. I think even in the Bible we are told we must pray for our leaders. So we do well when we recognize our leaders. We have leaders of commerce here with us, distinguished insurance leader here. So we are well represented. We are well represented. We have leaders from across the society. I'm going to talk to you about 4 bills, and Mr. Ferguson will speak to you generally about the Constitution and about the other 4 bills. So we will roll the tape. We're going all the way down to page 6. We're looking for the Caribbean Court of Justice. This bill has several aspects to it, but the one I'm going to spend a little time on is this proposal here, the CCJ to replace the UK PC. The UK PC is the Privy Council in London. Why do we want to stop going to the Privy Council? We have been going there as long as this country has been British. It turned British at the end of the 18th century, around about 1774, back in 1797 too. To go to the Privy Council, you have about $130,000 roughly to start with, if it's a civil matter. You have to find what is called a Privy Council agent in London. You have to have a Queen's Counsel in London. And you have to send somebody from Grenada, generally speaking, a lawyer. So you have to find the airfare. Even if the lawyer from Grenada is doing it free, you still have to pay the airfare and put him or her up in a hotel in London. And that comes up to about $130 to start with. Now that's important because the Privy Council never, ever acknowledged publicly that it is costly to go there. The first time the Privy Council admitted it is costly was last month when Antigua and Barbuda started talking about moving out of the Privy Council. The Privy Council sent a videotape and another gazette to say that, among other things, they will do something about the cost. They didn't say what they would do with any particularity. They said, we'll do something. Now let's pause about that for a while, because never before did the Privy Council make that admission. And it is only when the Antigua started having a public discussion about moving out, the Privy Council made that statement. So let's look at what is happening. In 2009, people in St. Anne Grenadines having a discussion about moving out of the Privy Council. And the head of the Privy Council at that time, Lord Phillips, said that publicly, it is time that Caribbean countries get out of the Privy Council, that we're taking up too much time of British judges, senior judges, and they're going to start looking at Court of Appeal judges in the UK to fit in. So that's 2009, no admission about costs. Well, the referendum was held in St. Vincent and the Grenadines, it failed. Back in 2005, 3 bills from Jamaica went to the Privy Council, and the Privy Council struck down the 3 of them. And all distinguished constitutional lawyers I know in the academic field criticized that judgment as being wrong. Later that year, 2005, the Privy Council judges, for first time ever, sat outside of London. First time in the history of the Privy Council, going back to 1792, when the first case from the Caribbean went to the Privy Council, case from Jamaica. Never before in the history of the Privy Council did they sit outside of London. But having cut down those Jamaican acts in 2005, the Privy Council then went to sit in the Bahamas. I am yet to see law reports, a case coming out of the Bahamas sittings, and they went back twice, from the Privy Council coming out of those Bahamian sittings. Why did they go to the Bahamas? They told us they wanted to make the point that you can count on the Privy Council for consistency, predictability, and I can tell you, if there is one thing that must be said about the Privy Council, when it comes to the judgments on the Caribbean, they are not predictable. Let me give you a striking example. Courts of law do not tell public decision makers what decision to make. That has been like Bible work for constitutional law. If a public decision maker makes a wrong decision, the courts will say to him or her, go back and decide it according to law. Out of the blue, an Antiguan case involving the freedom of the press observer publications, where definitely the Antiguan government was wrong in not granting a radio broadcasting license to Observer. Not only the Privy Council said that the decision maker was wrong, but the Privy Council said the radio broadcasting license must be issued. A business license needed by the company must be issued Never before did the Privy Council or any court, as far as I know, across the Commonwealth take such a stand. And they gave no reason for taking that stand. No justification for doing that. That is not predictable. That is not certain. So we reached the stage where the Privy Council left and they went to the Bahamas and were literally campaigning. This month, well, last Antigua started to discuss the matter. They didn't go physically this time. They sent a video clipping and they also sent a Skype product. And they said they're not lobbying. Well, that is lobbying. That is lobbying. So we have that admission from the Privy Council that going to the Privy Council is costly, which means that only about 5% of the population can afford, across the Caribbean, to go to the Privy Council in civil matters. I'm not talking about murder cases. We want to have equal access to the final appellate court. That's what we want. As a matter of fact, in the CCJ, when push comes to shove, you don't even have to go there. You can stay in Grenada and argue the case on electronic equipment. So what is the Privy Council saying now? They're going to do that too. Well, I ask you, all these centuries they never did it. Only now, because the Caribbean Court of Justice is doing it, the Privy Council is going to say they're going to do it? And what guarantee we have that they won't raise the cost later on again, and they wouldn't pull the plug on the equipment? We can't rely on that. So these are things you have to consider. Is it only because the CCJ is providing that facility that the Privy Council is saying, well, we're going to start doing it now? All these hundreds of years, why didn't they do it? What training do they give to our judges? None. Absolutely none. Since the CCJ has been on stream, it provides training. It has people, school children can observe what they're doing. I was at the CCJ. This is April. It had to be in February. And you had law students from across the Caribbean, not only in Trinidad, coming to the CCJ and having moots and being exposed to the final appellate court. That is what a final appellate court is about. So we are urging you to support it. Now, you may ask, what guarantee do you have that the politicians will not interfere with CCJ? And that is a fair question. It's a good question. Because we can't run away from the fact that we have had incidents in the past, including here in Grenada. So you ask me, what assurance can we give you that the politicians will not be able to interfere with the CCJ? This is the agreement establishing the Caribbean Court of Justice. And at page 4 of the agreement, you will see that between the CCJ judges there and the politicians here, there is a solid wall between them, so that the politicians can't get to the judges. What is that wall? That wall is the Judicial and Legal Services Commission. This is the body which appoints the judges of the CCJ. Who are these people? They come from across the Caribbean. Not one of the 11 members, not one, is selected by the politicians. Not one. Who then are these people? They are nominated by regional law associations like the OECS Bar, of which Mr. Ferguson here is the president. the Organization of Commonwealth Caribbean Bar Association, regional law teaching institutions like UWI, the Council of Legal Education, the University of Suriname. I noticed that Montserrat, that Martinique, last week or so, became an associate member of the OECS. So it's these organizations, the OECS, the CARICOM Secretary General, the nearest member on this body, who you say is a nominee of the government, is the chairperson of a public service commission who rotates across the Caribbean. So if it's the chairman of the Public Service Commission in Grenada now, next 3 years it would be the chairman of the Public Service Commission in Jamaica, and so on. These persons cannot be removed by any politician. You have people like Dr. Lloyd Barnett sitting on this body. So it's a wholly independent body. Now you may hear that I'm a member of that commission. How did I get there? The Director General of the OECS, together with the Secretary General of CARICOM, got together and nominated me. I never had anything to do with these gentlemen before. I never had any conversation with them. Never met them, never spoke to them, whether face-to-face or over the internet or on the telephone, never. That's how the system works. So because of this independent body, you are guaranteed that the politician cannot get onto the court anybody of their choice and cannot remove from the court somebody they don't like. But then you may ask, well, how is the court financed? Cannot the government starve them of money? The answer is no. When the court was set up, seed money of $100 million was established, raised by the Caribbean Development Bank to be paid back by participating governments as their share for financing the court. And practically all of that money has now been repaid. Well, who manages that fund? Again, there is an independent body, a board of trustees from across the region, put there by trade union movements, local banks like the Cooperative Bank here in Grenada, chambers of commerce, wholly independent bodies. That is why when the Privy Council examined this agreement, this is what the Privy Council said about the CCJ. In a case called Jamaica Council for Human Rights and Marshall Burnett in 2005. This was the testimony of the Privy Council about the CCJ. The CCJ is a court of complete independence, enjoying all the advantages which a regional court could hope to enjoy. Those are the words of the Privy Council, that the CCJ is a court of complete independence. As a matter of fact, other courts like the CCJ, like the European Court of Justice, are looking at the mechanics of the CCJ to see what they can learn from the CCJ. The financing, the choosing of the court. You're following the campaign in the US right now. And you know that top of the agenda is the question of choosing a new judge for the US Supreme Court. And it's all in the politics. I saw, for example, even a person from the Democratic Party saying that he's not too sure he will support the person nominated by President Barack Obama because he's not too sure about the judgments that judge might give. You can have that with the CCJ. You can have a president or a prime minister washing his mouth or her mouth on a nominee. And then it is left for the Senate, the US Senate, to approve the nomination. Straight politics. You can have that with the CCJ. And that's why the Privy Council was giving that testimony. So in terms of protecting the judges there from the politicians here, you have that commission. In terms of guaranteeing the independence of the court, you have the board of trustees investing that money and using the interest from the investment to run the court from day to day. It takes about $6 million to run the court every year. And we have over $100 million capital, not even including interest from the capital. So the court is in very good hands. Good. We're going to move on now. The next bill I want to refer to is the Name of State Bill. But the Elections and Boundaries Commission is coming next, so we could just step back one. This cannot be controversial. I'm not going to spend any time with that, really. All this seeking to do is to establish the Elections and Boundaries Commission, which will be an independent body. 2 members chosen by the Prime Minister, 2 by the Leader of the Opposition, and the chairperson will be selected by the Governor General, consulting with civil society organizations. You wouldn't be able to remove them. Barbados amended its constitution in 1980 just to have an Elections and Boundaries Commission replacing the supervisor of elections, a one-person show chosen by the Governor General, who continues to do his or her substantives as a public officer, so that really running the elections, running registration is a sideshow, so to speak, for that person. We want to put an end to that and have a full-time Elections and Boundaries Commission who will have a chief elections officer as the chief executive officer of the Elections and Boundaries Commission. That's not controversial. So we'll move on. That's the second bill I have to deal with. The third one is the Name of State. You're doing very good. Move on. This one here. All we want to do here is to reflect in the Constitution the reality of the ground. That really the name of the state is Grenada, Carriacou, and Petit Martinique. We say so from time to time. We want to make our sisters and brothers in Carriacou and Petit Martinique wanted, loved, appreciated by us in Grenada. That's what it is. When they feel that way, they will produce more. All of us will be happier. All of us will produce more. All of us will benefit. When we started this, some people were saying, the name too long. Grenada, Carriacou, and Petit Martinique, we don't have time for that. So we asked them, what is the name of the country which has given us this constitution, which has been running the country from 1776 down to 1974. Let's go through the name. The United Kingdom of Great Britain and Northern Ireland. That's the proper name of the country. But nobody calls it that way. Everybody says, you know, the Prime Minister of the United Kingdom of Great Britain. No, you said the British Prime Minister. You said a British Queen, for that matter. Similarly, if you're from Victoria and you go abroad, you and somebody asks you where you're from, you won't say I'm from Grenada, Carriacou, and Petit Martinique. You'll say I'm from Victoria and Grenada. Or the person from Hillsborough and Carriacou will say, I'm from Hillsborough and Carriacou. And you may elaborate more if you want. So we are asking you to support this bill. It's just making the Constitution conform to reality on the ground. I'm going all the way down, take as the fourth bill I'm handling, ensuring appointment of the leader of the opposition. What is this bill seeking to do? Learning from our history, we're learning from our experience. It happened in 1999, it happened in 2013. One party got all the seats in the House of Representatives. That is unhealthy for democracy. A parliament is a place where you have proposers and opposers. So we have come up with this idea that you're going to ensure that there's a leader of the opposition. How will it be done? The night of the elections, it emerges one party has won all the seats. The bill says that Her Excellency will call upon the leader of the party which obtained the most votes across the country, other than the winning party. And Her Excellency will have a conversation with that person. And that person will advise on who should be the leader of the opposition. And that person will be appointed. On being appointed, that person will have all the rights and privileges of any other member of the House of Representatives. It's as simple as that. They sent a man down from the Commonwealth Secretariat in London. He has been serving as advisor across the Commonwealth on legal drafting. And when he saw this bill, in the space of, 2 hours meeting with us at our headquarters at the stadium, he asked us 3 times, where you all got that idea from? And he's smiling. The first time he asked, we didn't answer. We thought he was just making a remark. The second time we answered. And he still asked a third time. Where did we get that idea from? From our experiences, from our history, from our constitutional culture. This doesn't take away from anybody. Now, some people will say, well, if the people across the country want only one party in the House, that's democracy. We do not agree with that. That is democracy if you are operating first past the post. But there's nothing sacred about first past the post. There is nothing sacrosanct about first past the post. First past the post means that in every constituency, the first contestant to get 50% plus 1 of the votes is returned as a representative. And you do that across the country. But at the end of the election day, a party can end up having 45% of the votes cast, and still the country doesn't have an opposition in the House. It's not a matter of the party, It's a matter of the national interest that people need to have in Parliament a different view. So it is not sufficient to say that is democracy. That is democracy if you're sticking slavishly to first past the post. And we have come to see first past the post does not always give the country good representation in terms of the country needing an opposing view in Parliament. This is a small...
I want you to stick here for a second. What would be the situation if you have more than 2 political parties running? But let's say the third political party cannot sit all 15 constituencies. Let's say they sit 6. But one of them, right, get more votes than the other party, who would have lost, let's say, party number 2, but seated 15 constituencies. So, in other words, that party would have had totally more votes than the third party, but you said the candidate that have the most votes will become the opposition leader. So how would that work in a situation where you have a party getting more votes than that other party, but because that single candidate in the party with less candidates got a majority of votes in that constituency? How do you justify?
No, well, it's not one constituency, it's across the entire country. Most votes across the entire country, not only one constituency.
I'm a little confused here. How do you choose that person? Could you repeat that? The person to become the opposition leader?
The Governor General will call in the leader of the party which obtained the most.
The leader of the party.
Will call in the leader of the party which obtained the most votes across the country other than the winning party, and be consulted with the leader of the party. Well, no doubt the leader of the party will say, or leader of the opposition will say, put me. Yes, please.
Well, a comment first. I'm seeing what we're trying to do here is to have a mix between our current system with a little bit of proportional representation by bringing in this leader. That's a comment. The question though is, when that person is chosen, they become the leader of the opposition, or do they become a member of parliament?
Both.
My follow-up question is, well, I am of the understanding one person from another party wins their seat, they become automatically the opposition. So if there are 15 seats and one person wins a seat, that person becomes the leader of the opposition. That's how it stands right now.
Yes.
Okay. So what would happen if one of the persons from the party that won 15 seats decides to move to the other side, of the table? That person, in the absence of this, would have automatically become the leader of the opposition. Now that the Governor General would have handpicked somebody based on the law to become the leader of the opposition, you have a full-fledged MP who have won the seat, crossing the floor. Can that person cause some confusion in the sense that say, look, I am elected by the people and I have a right to adopt the position? How would that play out? It may seem far-fetched, but I'm just saying, I don't know if this was considered when the bill was prepared, but it could happen that after the Governor General picks someone, or selects someone to become the leader of the opposition, someone who have been elected, who won the seat, decides to cross the floor, how would that play out?
There is provision for removing the Prime Minister. There is provision for removing the elected leader of the opposition. So it follows there will also be provision for removing this new concept of the leader of the opposition. So in your scenario, naturally the Governor General will look around and say, I can no longer sustain the produced leader of the opposition. And so provision is there for that. The objective is to ensure there is always a leader of the opposition. And if that person is so removed, taking your point, as leader of the opposition, he or she will automatically also cease to be a member of the House. We took that point 2 weeks ago and it's coming as an amendment. Good.
Question on that.
Yes, please.
If there's an independent person who wins his seat, he runs only in one constituency, and he wins his seat, would that person automatically become leader of the opposition?
I would think so, because you would not have had a situation in which all the members of the House belong to one party. And for this leader of the opposition to appear, it must happen that all the members of the House belong to the same party. So if there's an independent, that person is the leader of the opposition, the independent. Because there'll be no room for importing this leader of the opposition.
I thought, I was under the impression that you were going to go through with your presentation, and then so that, because there are questions I think that people would have liked to ask for the former ones that you brought forward. You know? So that's what I thought.
Usually that is how it is done, but that is how it is done. So we'll go to that. We'll present the bills first. Your points, take note of them so that you don't lose them. So what I want to do for the next 3 minutes is to talk to you about what is a referendum. So we're going to fast track all the way down to referendum key points 11. A referendum simply is an election in which the people vote on the question whether they approve of a bill passed by the House and the Senate. Because this is what the Constitution says. In relation to the amendment of certain provisions of the Constitution, when the bill is passed by the House and the Senate, the bill has to be approved on a referendum by not less than 2/3 of all the votes validly cast on the referendum. So a referendum is simply an exercise in which you, the people, answer the question, do you approve, I'm giving 2 examples here, do you approve the Constitution of Grenada, Caribbean Court of Justice and other justice-related matters Amendment Bill 2016 for an act proposing to alter the Constitution of Grenada? That's what a referendum is. In an election, you choose between people, candidates. But in the referendum, you are answering the question, do you want the United Kingdom to pull out of the European Union? Or where I'm operating in Bermuda, do you approve of same marriages? That's in June, July. Or in the Bahamas, do you approve of provisions to alter citizenship of the Bahamas? Or Antigua Barbuda, do you approve the Constitution of Antigua and Barbuda, Caribbean Court of Justice, Amendment Bill 2016 for an act proposed to alter the Constitution of Antigua and Barbuda? If you approve of it, you make your X here alongside yes with its symbol. If you don't approve, you make your X alongside no with its symbol. Since there are 8 bills, you are likely to have 2 ballot papers, likely. That is a matter to be decided by the supervisor of elections. But I'm answering based on how referendums usually. So you have a next one here on the same ballot paper. Do you approve the Constitution of Grenada, Name of State Amendment Bill 2016 for an act proposing to alter the Constitution of Grenada? And you have the same yes, no. No magic, no rocket science needed. Very simple. You, between now and then, will be told all what the bills are about, more and more. And when you go to vote, you vote accordingly. Thank you very much for listening to me so patiently. All right, so I will now invite the leader of the team on the Western Front, Mr. August Ferguson, a man from the West himself, just on the road in Palmas. He needs no introduction.
I want to suggest, Dr. Lee.
Mr. Ferguson is the president of the Grenada Bar Association, the president of the OECS, Organization of Eastern Caribbean States Bar Association, which brings together the lawyers from all across the Eastern Caribbean, Grenada in the south, all the way up to the BVI, passing through St. Vincent, St. Lucia, Dominica, Antigua, and so on. And he has been leading these organizations for years. He is a leading practitioner, private law here in Grenada, at the private bar. And he needs no further introduction. Nobody can say that Mr. Ferguson is a government agent or anything like that. He puts in quote the Governor General, he quote the Prime Minister, everybody. So happy am I to introduce Mr. August Ferguson. Warm welcome, everybody.
No, I'll see.
Oh, you're staying right there?
Yeah.
Good.
Thank you, Dr. Alexis, and good evening, all. Dr. Alexis has focused on 4 bills, and there are 8 bills in total, 8 individual bills that would go forward in the referendum, and for which the people of Grenada will be required to vote. So the task is mine to focus on the other 4 bills. And to put briefly, those 4 bills, in the order I will do them. 1 is the Rights and Freedoms Bill. 2, Term Limits for Prime Minister Bill. 3, Fixed Date Funds Bill. And the 4th bill, very uncontroversial bill, is the Restructuring Bill. And what I would wish to focus first and foremost on is the Rights and Freedoms Bill. Approximately 70 changes in total are being made to the Constitution. About 70 individual changes. When you strip them all apart to the lowest common denominator, you will find about 70 changes being made. And out of those 70 changes, 45 are contained in the Rights and Freedoms Bill. So it's an extremely important bill. And the Constitution, as you would note, Dr. Alexis has a more presentable copy than myself. His has the front cover. But the Constitution looks like. It's only 111 sections, small document, 109 pages, and about 8 chapters. 8 chapters. And what the Constitution provides, this very tiny document, referred to as the supreme law of the land, what it provides essentially are fundamental rights and freedoms. That's a Constitution provides fundamental rights and freedoms, and indeed chapter 1 of the Constitution focuses on fundamental rights and freedoms. And it also sets out, in very broad terms, the structure of the state. And that is why I always try to remind people about the concept of the separation of powers. Because in our type of democracies and our type of constitutions, implicit in those constitutions, and I say implicit because it's not expressed, is the concept of powers. And what that simply means is the concept that the state is divided into 3 arms, or consists of 3 arms. One arm is the legislature or parliament, and the legislature is the lawmaking arm. And parliament, as you know, comprises 2 houses, the House of Representatives and the House of Senate. The House of Representatives elected through general elections every 5 years, 15 seats representing 15 constituencies. The House of Senate appointed 13 members, 7 appointed by the Prime Minister in his own deliberate judgment, of course, recommends to the Governor General the appointment, 3 through interest groups in consultation with interest groups, and 3 by the leader of the opposition. So that's the legislature for you, captured lawmaking. Then you have the executive arm of the state, and that's principally cabinet. And the cabinet is really policy making when you strip it apart. Cabinet consists of ministers of government, and they drive policy. They determine issues as roads, hospitals, stadium, health centers, where they go, when they go, to what extent they are provided. Education, that's for the executive. And the third arm of the state is the judiciary. And the judiciary is really the court system or judges, magistrates, and they are independent of the executive and the legislature, and they interpret the laws passed by Parliament, they determine legal disputes. Finally, you don't go to the parliamentarians to say what they mean by these laws. The court, whatever the court says the law means, that is what the law means. So you have these 3 arms, the purpose of which is to provide checks and balances and to prevent abuse of power. And I always try to urge people, I always say, if people understand the separation of powers concept, then they would understand fundamentally what the Constitution tries to do. It tries to prevent abuse of power by the state against individuals. And that is why you have fundamental rights and freedoms. And if you note, it's fundamental rights and freedoms, not just rights, but fundamental rights. Rights that go to the dignity of the individual. And the Constitution as the supreme law that creates Parliament and says to Parliament, go pass laws for the peace, order, and good government of the country. But when you pass in laws, don't pass any law that is inconsistent with this Constitution, or else the court can strike down these laws as being void. Those laws that would take away fundamental rights and freedoms, because the supreme law, the Constitution, provides these fundamental rights and freedoms. And it is in that context I would wish to mention the Rights and Freedoms Bill. Essentially, what we have in our present Constitution, Chapter 1, the first 16 sections really focus on our fundamental rights and freedoms. And these include the right to life, the right to personal liberty, the right to freedom of movement, the right to freedom of expression, the right to freedom of conscience, the right to freedom of assembly and association. It provides protection from arbitrary search and entry, protection from cruel and inhuman punishment, protection from slavery and forced labor, protection from deprivation of property. It protects freedom of movement. All of these, the first 13 sections, identifies these individual rights. And the Constitution, Section 16 itself, provides the vehicle for persons who allege that their rights either have been, are being, present, or are likely to be future breached by state officials or the state, as the case may be. And they then can go to the court. Section 16 says you can go to the Constitutional Court for relief. And the Constitutional Court, note, that's the arm of the state responsible for interpreting our laws, interpreting the Constitution. And the Constitutional Court can fashion remedies. Broadly, it gives that court rights to, or board powers to fashion remedies to address the breaches. So if, for example, the fundamental rights provision of the Constitution says every person is entitled to freedom of expression, then Parliament can't pass a law next week that says there shall be no freedom of expression, because that will be inconsistent with our Constitution. So these are rights that have been there for ages. It is now 42 years since our independence. And what the Rights and Freedoms Bill aims to do is to introduce new fundamental rights and freedoms and refine existing fundamental rights and freedoms. And in a sense, elevate current ordinary rights to the level of fundamental rights. And I will explain. One of totally new rights being included in our Constitution, and it will be a first for the Caribbean, is the rights of every individual to protection of his intellectual property, and the duty of the state to protect and to promote intellectual property rights. And when we say intellectual property rights, what do we mean? Intellectual property are creations of the intellect, creations of the mind. And that's why you have, broadly speaking, you have copyright, you have trademarks, you have patents. Patents deal with inventions. And we have people in Grenada who invent stuff, like the cane juice man in Grandance. Those machines that he juices the cane from. All of these are his creations. And in fact, those are patented outside of trademarks, deal with signs. You know, Nike have the sign Coca-Cola because these things distinguish one product from the other. So you might find Coca-Cola, you find people calling it cola, different names, looking like Coca-Cola, but not Coca-Cola, because that's a specific brand. So trademarks distinguishes brands. And then copyrights, where you have copyrights, protect the works of authors, calypsonians, dramatists, performers. And we have, for example, our calypsonians who sing year after year, invest heavily in their music, and the only benefit they can get is if they happen to win the crown or place really high up. Because at the end of the day, once they sing and they produce music, somebody just cut it and go on the sidewalk and sell. The people make money out of the calypsonians don't. This elevation of introduction of intellectual property rights, that is totally new. When the independence came about in 1974, nobody spoke intellectual property. In fact, that is a big area for economic growth now. And therefore, writers, dramatists, performers, calypsonians, they will all benefit from intellectual property rights. And Grenada's constitution is one of the first, would lead the way in the Caribbean as far as intellectual property rights. Secondly, we have in the field of education as a fundamental right protected under the Constitution that every child up to 16 years of age has the right to fund publicly funded primary and secondary education. And that is actually a very bold step to include that in a constitution at the level of a fundamental right. It translates the concept of education is a right, not a privilege. And the state therefore has a duty, because there's a consequence. Somebody, if you don't, can bring a constitutional motion for breach of the fundamental constitutional right. And that is why, again, constitutional issues and constitutional reform has gotten wrapped up in a lot of partisan politics. Those who say vote no to constitutional reform, shooting messengers, not examining messages. Because at the end of the day, as I always say, the central question is, who will all of these changes benefit? Will it benefit a political party? Will it benefit a government? Will it benefit a particular section of society? Or would it benefit the people? who would their property rights benefit? And the answer is the people. Who would the introduction of the education, compulsory education, publicly and funded education for all children up to 16 years, again, is the people. As an elevated right, you have what is a child legislation, and that was passed, in fact, pioneered by Dr. Alexis when he was in government back in 1991. And there was a lot of debate about it, but put simply, a child is a child, essentially recognizes no distinction between children born in wedlock and out of wedlock. And a lot of people don't understand the significance of that legislation, quite apart from, well, a child is a child, yes, but before legislation was introduced, what it meant is that a child who was born, a child in our laws, basically was defined as a child born in wedlock. So if, for example, a parent died and left a will, as the saying goes, there are two ways you can die legally, with a will or without a will. And if a parent died leaving a will and did not name his or her children, and there were 2 children born in wedlock, let's say, and 3 children born out of wedlock, and he said, I leave my 1 acre of land to my children, then only the children born in wedlock prior to 1991 would take. They were the only ones entitled to benefit because a child in law meant a legitimate child only. What this law did was to remove that distinction and declare a child is a child, whether born in or out of, and to remove the concept of illegitimate children. Because in the Caribbean, most children are born out of wedlock in any event. And if you die even without a will, intestate, same example. And you had 3 children born out of wedlock, 2 in wedlock, you die without a will, only the 2 children born in wedlock would benefit. Subsequent to 1999, with the introduction of that law, then all children benefited. And that child is a child right is now being elevated to a fundamental constitutional right. Equality of children, essentially, before the law, whether born in or out of wedlock. And what elevating it to a constitutional right simply means is that no parliament in the future, because once it's an ordinary right, all parliament has to do is by a majority change the law. That's all that parliament is left to do if they want to change some ordinary right. And if there is a group, some religious fundamentalist group, for example, who does not believe in it, and they have the majority in parliament, they can change it. When it's elevated to a constitutional fundamental right, parliament cannot change it on its own. Ultimately, like constitutional reform, they'll have to go to the, first of all, you'll have to get a special 2/3 majority of all members of parliament. You have 15 members of the House of Representatives. 2/3 mean that 10 must vote in favor of it. And after that, you must go to the people in a referendum. That's to change a fundamental right. An ordinary right requires just a simple majority in parliament. 13 people happen to be in the House, 6 vote against, 7 vote for, and the law is changed. So that is what is by elevation to a fundamental right. Another important change or elevation of a right is the right to vote. The right to vote is really, though impliedly in the Constitution, because the Constitution provides for general elections, but it is not an expressed fundamental right. And voting, the right to vote, as I always say again, is not a right that has been around for ages. The first elections in Grenada, for example, based on universal adult suffrage, took place in October 1951, less than 70 years ago. And we have moved from a situation from slavery, where slaves had no rights. In fact, slaves were personal property, or personal properties of slave owners. Moving now to rights before 1951, where it was the right was related to income and property, and universal adult suffrage in 1951, and that right has remained an ordinary right, but it is now in constitutional reform being elevated to a fundamental right under the Constitution. Moving quickly along, again, freedom of association. Section 11 of our Constitution provides for freedom of assembly and association. And what it provides is that every Grenadian has a right to freedom of assembly and association, and goes on to say, and in particular, the right to join trade unions of your choice, to participate and join trade unions of your choice. The refining of that section involves the addition, apart from trade unions, of political parties. For the first time, political parties drive the politics and the voting process in the country, but they are not reflected in the Constitution at all. And it now gives Grenadians the fundamental right to join a political party and participate in whatever political party they wish to participate in. So apart from trade unions, expressly stated in our Section 11, would be political parties. And addition, expansion of categories also relate to the protection of discrimination, and very importantly, the categories as social class, and very importantly, disabilities protected. So if you are suffering from a disability, again, you are protected as a specific category, just added, that protected from discrimination. And all of these are enforceable rights under the Constitution. Moving quickly along, you have, apart from these fundamental rights and freedoms added to the section, or chapter 1, you have two additional categories, or two additional subchapters, 1B, 1C, added under the Rights and Freedoms Bill for the first time. And these relate to the section, Directive Principles of State Policy, under the general heading. And under Directive Principles of State Policy, certain obligations and responsibilities are entrusted on the state. Whichever party comes to power, whatever manifesto that you have, you'll be under subject to the Directive Principles of State Policy. And what do these? Again, briefly, protection of the environment. The state has a duty to protect the environment. And we have moved again in the 70s. Nobody spoke environment. Now, environment is a big thing internationally. It imposes a duty on the state to protect its natural resources for the benefit of the people of the state. It imposes a duty on the state to protect against the adverse effects of climate change. It imposes a duty upon the state to protect children. That children must, again, and you hear the advocates of child rights, must have a voice and must not be exploited, whether mentally, physically, psychologically, or otherwise. It also imposes a duty on the state to protect and promote the family. It imposes a duty on the state not to unduly burden the state with and what is referred to as exercising fiscal responsibility. So those directive principles of state policy are really moral guidelines. It's like the moral compass to guide the state, irrespective of the philosophical position of the respective parties that may form the government. They have these duties. once you get into government. And all arms of the state, whether it's in parliament, or whether it's in the court, or whether it's at the level of the executive or cabinet, they must all be guided by the directive principles of state policy. The other chapter, 1C, again, a new chapter, very unique to our own constitution, and that is gender equality. And what gender equality provides? For equal rights of men and women. And this is a very interesting section itself, because again, you have heard about the rights movement, and women have been very vocal in particular. That is now encompassed in the rights section of the Constitution. So with gender equality, there must be equal access of men and women, and it's not about women, it's not about men, it's about equality and equal access of men and women to academic education, to vocational education. So for example, where there are scholarships to be provided, then you can't give all men or all women. You must take into account, the state has to be guided by gender equality principles. There must be equal opportunities. There must be equal for equal work. And very interestingly, under the gender equality, is that the appointments to state boards and corporations, that when you are appointing, you must take into consideration gender equality. So when you're putting people on boards, they must not be all men, all women, to have as perfect a balance as you can have. It would not always work out mathematically so, but the state has to be guided by gender equality principles that would allow equal treatment of men and women. Very interestingly, it expressly states under the gender equality section that political parties, for example, political parties must strive to promote gender equality when choosing candidates for elections. It expressly states that under the gender equality section. So when you are choosing candidates, and Grenada has a good record in the Commonwealth when it comes to choosing males and females. So the ideal on the gender equality basis will be 8-7. It won't work out so. But when you are choosing candidates, when you are making appointments to the Senate, you must take into account gender equality. And the language of the Constitution will change, because the language of the Constitution now favors male. It speaks about his and him, meaning when you see it, it also means her. But the language will change to say his or her, him or her, as the case may be. It will include or embrace both the female gender and the male gender. So those in the rights and freedom section, that encapsulated would be what are some of the highlights of the Rights and Freedoms Bill. As I said, 45 changes, but contained in one bill. So you don't have to vote on 45 individual items. You'll be voting essentially for one bill that encompasses all of these changes. The other bill and other bills can be shortly disposed of, because term limits for Prime Minister, and that seeks to impose a 3 consecutive term limit on the office of Prime Minister, not on parliamentary representative. So you can be a parliamentary representative for however long. But the holder of the office of Prime Minister, the term limit, to impose a term limit of 3 consecutive terms. But that will not be included in the Constitution. The Constitution would authorize Parliament to pass a bill that would allow for 3 consecutive terms, and after that, the person cannot hold the office of Prime Minister. And so I said again, the Constitution will change to allow Parliament to do that. Because once you put all these things in the Constitution, then if you have to change it, if you have to change the number of terms in the future, then you have to come back to a national referendum. And as it is now, the Constitution allows unlimited terms. So you must change the Constitution to authorize Parliament, and so Parliament would not be inconsistent with the present terms of the Constitution. And then you have the other fixed date for elections. Fixed date for elections, and that is now, again, to allow Parliament to pass a law that would require fixed dates for elections. And again, because of the present construct of the Constitution, Constitution being supreme, Parliament cannot go and pass an ordinary law like that now. And as we know, throughout the region, mainly elections, you will have, like in Jamaica recently, since October, the talk was that Portia Simpson Miller will be calling elections. And every meeting that the PNP holds, every major activity, they expected election date to be called. It was only called in February. In fact, the business community in December made a special request not to call elections in December because it will disrupt business. And the feeling is that whichever party is in power, they always have an advantage because they would call, as they say, the Prime Minister has the date in his back pocket and he calls it. And then it scrambles because either there's a short period for campaigning, as the case may be. So the idea is to have a fixed date that everybody knows in the future elections will be the third Tuesday in whatever month. And the last bill, because the evening is really years, is the restructuring bill. And that bill really is uncontroversial. It allows the AG, the Attorney General, after the constitutional referendum, to make adjustments, to rearrange sections of the Constitution, not substance. It allows rearrangement of the Constitution to accommodate whatever the people would have approved. So you'll have renumbering, reparagraphing, rearranging, and the Parliament ultimately has to approve it. But nothing substantial. They can only approve what has been passed. So it's basically to allow that, and it's a matter of form. So in a nutshell, these are the 4 bills. So in the 8 bills in total, just to recap, the Rights and Freedoms Bill, the CCJ Bill, fixed date for elections, term limits for Prime Minister, ensuring leader of the opposition, name of state bill, Elections and Boundaries Commission, and the restructuring bill. Thank you, and I think the floor is open for your questions.